Hi, good afternoon, everybody. My name is Corey Cattell. I'm a staff attorney with Lone Star Legal Aid, and I'm here as part of a ongoing local law live series. I'm joined by a staff attorney out of our Richmond Rosenberg office, Megan Beasley. Megan, could you introduce yourself briefly?
Yeah, hi everyone. I'm Megan Beasley. I'm excited to be talking to you today. I work out of the Richmond office in Fort Bend County.
And so what we're here today is to basically talk about estate planning, why it should be important to the individuals in our communities, and what we as an organization can do to assist individuals who are seeking help on estate planning questions. Now, to start this off, this presentation is intended to serve as legal information. It does not constitute specific legal advice for an individual's situation. We ask that you contact Lone Star Legal Aid. Our phone number is 1-800-733-8394. Or you can go to www.lonestarlegal.org for more information on legal assistance and to potentially put in an application for our services. Lone Star Legal Aid does not discriminate on the basis of race, color, religion, gender, gender expression, sexual orientation, age, national origin, ancestry, disability, marital status, or military status in any of its activities or operations. So we do ask that people contact us if they have any questions about the matters that we're going over today. Now, part of the reason why we're doing this estate planning, we've done this a couple of times over the last 2 years that the country has been just embroiled in the global pandemic. We wanted to take a little bit of time today to basically go back over some of the estate planning essentials and talk about those. Now, essentially, estate planning is we refer to it internally as a packet. It's a series of documents that we'll go over today that are designed to assist individuals with end of life or incapacity issues. So if somebody were to get sick, something tragic were to happen to an individual, it's to ensure that bills get paid, decisions continue to be made, and that information can continue to flow from that individual to family members through, say, HIPAA release and things like that for the hospital. It also includes information, or the estate packet itself also typically includes a will. The purpose of the will and other estate planning vehicles that we use in the actual probate process for wills, these things are designed to assist with the creation and preservation of generational wealth. It's to make sure that property is divested properly to individuals in the family, and that it's essentially given to people who can take care of the property. And most importantly, that a true chain of title is created upon a owner's passing. The importance of this is to get away from a legal artifact called heirs property, with the problem being that if a piece of property is owned by an individual, within 2 to 3 generations, if no estate planning is done and the probation of that property is not done properly, it could create a situation where 5, 8, 20 people own a piece of property simply because of the passing of individuals in the family. When that occurs, the paying of taxes is impossible. Getting assistance through organizations such as FEMA for natural disasters is impossible. And clearing up the chain of title ends up becoming a life or death issue for some people. Without the ability to clean up the title, ultimately the property can be sold, taken by the government, or ultimately not able to be repaired in the case of a natural disaster. We're trying to stave off those issues ahead of time by getting estate planning done in our communities to the best of our abilities. So that's kind of the reason why we're here today, and that's the reason why we would hope that you would feel that this is important to you. So with that out of the way, I want to we're going to talk about some of our estate planning individual documents. These are going to be like the powers of attorney, the HIPAA document. This is also going to be like directives to physicians, documents related to guardianship. At the end, we'll talk about wills and will alternatives. Um, But I think I'm gonna turn over to Megan. Megan, if you could, a big question that people might have or get confused about is the different types of powers of attorney. Can you explain the difference between medical and durable or financial powers of attorney?
Sure, Corey, great question. So just in general, to remind everyone, a power of attorney is a document that you draw up as the principal, giving someone else, the agent, the power to make decisions for you. So the medical power of attorney gives that person the ability to make medical decisions for you. It's narrow. It goes into effect when you become incapacitated. The durable power of attorney is broader. It lets the person make decisions about finances, legal decisions, decisions about property. And you choose when you draw it up, if it goes into effect right away, or if it only goes into effect when you're incapacitated.
Okay, and so what is incapacity? Can you give us some more information about that?
Yeah, so it's a medical definition as much as it is a legal definition. It's basically a doctor would have to determine when you can't make decisions for yourself based on your medical condition.
Okay. And so why should individuals be concerned about the financial power of attorney and not just the medical power of attorney?
Well, during COVID, as a lot of you know, hospitals have new protocols. It's harder for people to get in and out, to visit with the patient, meet with the patient. So it's good ahead of time to name somebody who can help pay your bills for you while you're in the hospital, in case they're restricted from meeting with you. So it's kind of a good planning decision during difficult times like these.
Okay. And so what occurs if I don't have a medical power of attorney? If I were to get COVID, and I'm incapacitated for whatever reason, if I don't have a medical power of attorney, what happens to me?
So if you're in the hospital and you become incapacitated without a power of attorney, it's up to the hospital's guidelines who they choose to make decisions for you. It's usually a next of kin. And it's possible, depending on your situation, that you wouldn't want your next of kin to make decisions for you, which is why we have these powers of attorney where you can pick anyone that you trust to make the decisions for you. One example is if you're going through a divorce that's not finalized yet, your next of kin would be your wife to make decisions for you, your spouse. And you might not want that person. So then it's good to have a power of attorney choosing someone else.
Okay. And the doctors are required to listen to that individual's basically decisions if I'm unable to. Is that correct?
Yes.
All right. And what's the time frame for these documents? How long do they last?
So powers of attorney, they can last kind of as long as the incapacity lasts. So if you still have capacity, the ability to make decisions, you can always revoke your power of attorney, which ends it. You can always make a new one with a new agent. As long as you have capacity, you get to choose when they start and end. But if a power of attorney is in effect while you're incapacitated, it goes on during the incapacity until somewhere down the road, if you stay incapacitated, maybe a court would make a decision what happens next.
Okay, wonderful. So next I want to talk about, I know we've talked a good bit about the medical power of attorneys. I also want to talk about kind of the medical records and the HIPAA release. So let's say I'm in the hospital and I want to allow a loved one access to my medical records. How would I typically make that happen?
So you would have to fill out a HIPAA release. So HIPAA is the name of a federal law that protects a patient's privacy. And so in order for your patient information to be given to someone else, you would have to release that with a form called a HIPAA release, telling the hospital who they can give information to. So if you have a medical power of attorney, that agent has to make medical decisions for you. It's a good idea for that agent to have a release to be able to get your medical information so they can make the best decisions.
Okay. And so my understanding is legal aid will actually prepare the HIPAA release forms beforehand so that you have them ready to give to the hospitals?
Yes, that's correct. Legal aid can help with all of these things.
All right, wonderful. And then I think
And
next
now
one.
I think, Corey, is it my turn
Yes,
to ask you questions?
I believe so. I'm sorry. I'm looking
Okay.
at questions that are coming in from the audience. I apologize.
Yes, and we will answer those closer to the end, um, if that's okay. And so, Corey, we've been talking about like the decisions that an agent can make, but how does the agent know what decisions the principal wants them to make about their medical care?
So for medical powers of attorney, typically you have discussions with the person that you've appointed as your medical power of attorney before anything happens to you. Now, your preferences that you have suggested to doctors or to family members, anything that you've said prior to your incapacity has to be upheld. A medical power of attorney does not give the agent carte blanche to disregard your preferences after you are incapacitated. And so, even if they disagree with you about certain health decisions, they are required to continue any type of care that you have specifically requested or demanded. So, it's important to speak with your loved ones or put in writing what your expectations are um, with your care down the road.
And then,
Uh,
yeah.
Well, I was also going to
How-
say, I apologize.
yeah.
So we also have a form that we can provide called directives for physicians, and these documents are essentially designed to um, give out certain situations in which the person has made, or it's to explain certain situations where the person has made explicit instructions for their incapacity.
And so when you do a directive, do you kind of try to think up every possible thing that could happen to you? Is it limited in some way?
So the directives themselves typically cover a limited number of situations. If you want to put more in there free form, you are allowed to. But the big ones that the directive to physicians it, it is really intended to cover are situations in which you find yourself incapacitated on some sort of life supporting care, that without this sort of life supporting care you would pass away. The first situation is, what do we do, what do you want done in in that case? Do you want to remain on life support, or do you want to be essentially placed on hospice and allowed to pass naturally? The second situation is a case where you have been diagnosed with a terminal illness, that terminal illness will last a known amount of time, a limited amount of time in the future, typically less than 6 months, and you are not able to give your feelings about whether or not you want aggressive medical treatment to try to stop that condition or that situation from happening, or whether you would again allowed to be placed on simple hospice care and allowed to pass naturally. And so these are only for situations in which some sort of critical care or intensive care is being used um, to basically keep the injured individual alive, and to let their wishes know in those situations. Now, your directives to physicians can include other situations that you might think up. You can have, if you have certain religious restrictions, say to blood donations or something like that, you can include those into your directives to physicians, although that typically tends to be a bit more rare. But you can add certain directives to certain specific directives to the document that you wish to go to your doctors.
And then I know we're talking about some pretty heavy stuff here, Corey, but it's always good to be prepared, right? That's kind of why we're talking to everybody about all this stuff.
It is the unfortunate nature of talking about estate planning. We are talking about the event of something tragic happening that we would all wish didn't happen. And it can be morbid to talk about and think about and have necessary discussions with one's doctors and family members. But we find that preparation in these areas are key. We would really rather have individuals know um, know what to expect so that their family knows what to expect as a situation develops.
And Corey, we've been talking about kind of temporary incapacity with powers of attorney, but what happens if someone becomes permanently incapacitated?
So for issues of permanent incapacitation, we turn to guardianships, which are a completely separate part of the law and are outside of the scope of the discussion today, except we do have a legal document that we can draft up, and we normally do as part of our estate planning packets for guardianships in case of need. The idea behind a guardianship in case of need is that you are allowed to essentially designate two classes of individuals. You are allowed to tell a court who you would like to be your guardian, and you are allowed to tell a court who may not be your guardian. While the court does not have to take your suggestion on who can be guardian, because there are other requirements for guardian. You have to make sure that that person doesn't have any felonies or um, any other, you know, they're bad with checks or something like that they've had run-ins with the law. You have to make sure that there's none of that. They also have to be willing to do it. There's certain other restrictions. So the best you can do is suggest to a court who you would like to have be your guardian. But the court puts weight on that. They are supposed to put a good bit of weight upon your suggestion if that person is interested. Conversely, if you tell the court that a particular person is not allowed to be your guardian, the court may not appoint that person guardian under any circumstance. Regardless of whether the court believes that it would be in your best interest or not, you've made it clear that that person is not to be your guardian. And so, if you have an individual in your family who you think may try to take advantage of a situation, it's unfortunate, but sometimes we have family members that we love but don't like. Um, if you have that sort of situation, guardianships in case of need documents can help uh, essentially make sure that your wishes as far as a guardianship are respected.
Just to be clear, those are documents that you would fill out ahead of time before you have any kind of incapacity, and then they go into effect if a guardianship becomes necessary. Is that right?
So if
Okay.
so, if somebody has to file a guardianship, an application for guardianship for you. The court, this document would essentially be given to the court so that the court understands what your wishes prior to your incapacity were. That's the entire point of them.
Okay, so now should we transition into wills?
I think that we will, and this is going to be kind of the meat of the rest of our discussion. This is the biggest one of our estate planning documents. So the first thing before we get too far into wills, I do want to talk very briefly about some of the concepts that we'll be discussing here. And first things first, we have this concept of the estate. And so when an individual passes away, what falls into the estate is essentially anything that they own at the time of their passing, plus any debt that they have. And this estate will either be a positive number or a negative number. Now, to allay anybody's fears before we get too deep into it, if you have a loved one who does pass away and they owe more than they had, the heirs are not required to ever take on debt. You are allowed to let the estate just pass as it is. Nobody takes ownership of any of that property, and eventually that will settle out on its own. You're not required to probate that property. You're not required to take on that debt. But what the goal here is to, if we can, we want to take as much property that an individual owns, and we want to move it out of the estate prior to death. And the purpose of this is that if you own a house and a bank account and a car, and you owe money to the hospital when you pass away, or if you owe money to Medicaid or to the government, if you owe back taxes, whatever it is, if you can move these big ticket items out of your estate, it doesn't matter what happens in the probate, those items can no longer be touched because they fall outside of the estate, and therefore they're outside of probate. And so I think that's what the crux of our conversation, what the rest of our conversation is going to be about, is that distinction.
So is there a difference between a will and then a will alternative? What's a will alternative?
So will alternatives are going to be kind of what I'm talking about, that vehicle to get things out of the estate. It's going to be transfer on death deeds are typically used for homes. There's a different version of this called a ladybird deed. And so we prefer, at least I have a preference for transfer on death deeds because it allows some restrained control on the property right up until the time of passing. But the transfer on death deed essentially allows a transfer out of the estate for the house, and then we have things like survivorship agreements for bank accounts, and we also have title transfer documents for vehicles. So for cars and the like, we can transfer titles on death.
So for these big assets that I have, if I want to transfer them not through my will or through the estate or through probate and want to do one of these will alternatives, how do I do it?
So for transfer on death deeds, these are actually available online. We can also assist with the creation of them. And it essentially is just like a deed, like you were giving your house to somebody. But the entire purpose of the transfer on death deed is that this document is essentially placed on file with the county. And so upon your death, at the time of your death, the title transfers over to that person without any further action on your part. It just becomes their property the moment that they have a death certificate. And so it never goes through the probate process. This same type of legal vehicle also exists for bank account survivorship agreements. The idea of survivorship agreements is the person you put on there is not entitled to get into your bank account. They're not entitled to get to any of your records. They can't use your credit card while you're alive. But at the time of your death, they also don't have to probate your estate before they can get access to that money. The money is just immediately transferred to the individual on the survivorship agreement. And I believe it's a VR 121 is what the vehicle transfer is. It's just like a Todd deed, but it's essentially for a vehicle that's registered in the state of Texas. And so you can have these documents ready to go. You can have these documents on deposit with the county court or county clerk, and make sure that they come into effect upon somebody's passing.
So even if I want to transfer all those things with will alternatives, do I still need a will? And what would be necessary to go into the will?
So yes, we absolutely still want to have a will. We want to be able to dispose of not only um, your personal effects, but we also want to catch all for anything that you happen to get that you don't do a transfer on death deed prior to, say, passing. This is as a personal anecdote. I actually had a grandmother who was incapacitated, and after her incapacity, but prior to her death, her sister passed away, and she was left a very large amount of property. And there was no way essentially for her to designate what she wanted to have done with that property due to her incapacity. And so that's what a will can do, because a will not only capture specific things that you own, but you can also do a catch-all. You can say anything else that I have at the time of my death, I want it to be split up in these ways. You can direct how you want ownership of those things to be split up. Now, as far as the will itself, you do have to have you have to meet certain requirements in order to create a will. You have to have what we call a testamentary capacity. And the idea behind testamentary capacity is you essentially have to know that you're creating a will. You have to have the ability to form that thought in your mind. You have to know what you own. You have to know who your kin are, and you have to know how you want your property disposed of. It's a lower level than contractual capacity. It's not the same. It's not the same level. You have to have more capacity to do things in the world in order to be able to buy a car than you do to sign a will. but you do have to know who you are. You have to be lucid enough to understand what you have and that you are disposing of this property. The wills themselves also have to be written. They have to be signed in the presence of witnesses. A notary is going to be involved in order to get everybody's information about the signing of these wills, and all of this in the actual the signature process of the will can be it can be a bit of an event. It's a lot of people in a room, and we really prefer that these types of situations happen around attorneys that can direct who signs what when, to make sure that all the wording and verbiage is correct on the will, that there's nothing left out, and you won't have a problem when it gets to probate. I want to remind everybody that there's a 4-year statute of limitations on probate. And outside of good cause, if you do have a will, you want to make sure that your family members know that you have a will. They know where a copy is, because when you pass away, they have to basically take it to court within 4 years to get that taken care of. But the goal here is to be able to take care of that as easily as possible. It's far easier to do it with a will than it is with anything else.
Now, what if I want to give someone some property in my will, but I really don't want their spouse to get any of it? What do I do?
So this is we've encountered this problem before, with people who come to us, and it's, I want to make sure that my daughter gets certain property that I have, but my daughter's husband is questionable. Things of that nature. We love our family members, but we don't necessarily love who they love. And we do have a thing in Texas family law that kind of covers this. There's this idea that in a marriage you have community property and separate property. Your separate property includes anything that you inherit. So if you receive money through an inheritance from somebody, that money does not automatically belong to your loved one. Now, there are ways that it can get enmeshed into the community property estate, but ideally it belongs to the person that you're giving it to, not to any of their family members. And so we still do suggest that people give their property to the loved ones that they want to, without necessarily having to worry about that. So I want to, Megan, to kind of toss this back to you. So for individuals who aren't able to get an attorney before they become ill, before they become incapacitated, how can, or they're seeking attorneys, what can they do right now to kind of protect their property until they have an opportunity to speak to an attorney?
Yeah, so in Texas, we have holographic wills, which means handwritten wills that can be valid. You just have to make sure that when you're writing it out, the entire document is handwritten. It can't have a mixture of type and handwritten because they will ignore the typed portions. So you want it all to be handwritten. You still want to have testamentary capacity. You're 18 or over, and you know that this is a will dispersing the things that you own. And then you also want to make sure that when you're writing it out, that it's not just a list. That could be some other kind of list. You want to make sure that it looks like a will that you're writing in there, that you want these things transferred upon your death. But of course, a holographic will is not ideal. You want to be sure that when you have the time and ability to speak to an attorney, that you then can write up a typed will.
All right, wonderful. And so, yeah, we do implore all of our community members to absolutely reach out to an attorney, whether it's us or anybody else, to help secure the estate. This is important to your family members. It's and they might not recognize right off the bat why it's so important, up until they find out that you have everything taken care of. I know that we had at least one community question. We had, I believe, how can one do a right of heirship? I'm not quite sure what you mean by right of heirship.
Do you think they mean affidavit of heirship?
I do. I do think that they mean affidavit of heirship. Now, an affidavit of heirship is a way to essentially probate an estate, in a very roundabout way that takes a long time to go through the process. Affidavits of heirship are finicky. I would have to suggest that individual please speak with an attorney. You can put in an intake with us, or please reach out to a local attorney, because that's a far more complex question than I would be able to answer, even if I had another 30 minutes. And so, yeah, but affidavits of heirship, there are different types of probation or probate documents or legal vehicles that you can use, such as affidavits of heirship, small state affidavits, and then you get into administrations of estate and probations of will. And so we would rather things happen with will probation than anything else. But actually, I take that back. We would prefer if everything pass outside of the estate and that your family members are taken care of without ever having to step into a court. But in lieu of that, we'd rather have a will than anything else. And so that's the goal. But yeah, please, to kind of answer the question, please contact an attorney about that. They'd be able to give you far more information. But I think that that pretty much wraps up our little local law live thing here today. We hope you enjoyed the chat, that it was informative. And from all of us here at Legal Aid, thank you and have a great day. Megan?
Thank you very much, and reach out lonestarlegal.org if you need further information. Thank you.